So you have not convinced Paul Farley to close the file, and it looks like you're going to have a hearing. What do you do? Douglas Crane has a panel this morning that's going to take us through that process, and he will introduce the members of his panel to you. Thank you.
Ladies and gentlemen, I'm pleased to be here this morning, and I'm happy to introduce your panel briefly. I would like to say that when Laurel Evans and Paul Turkstra saw me last November or December to participate, they were so persuasive that when I woke up a few months later, I realized that I had been conned into participating in this program and the one next week. I also found Laurel's notes and Paul's notes in my office. Their briefing notes where they were told by someone, if possible, get a Hamilton lawyer who was called in 1963, because this is 30 years since the call and to be politically correct. Unfortunately, when they checked the 63 records, they found that Walter Station and Nick Borkovich were appointed judges, and after they checked a certain MP's records, they found that the only two lawyers in the class of 63 not appointed judges were Leon Paroian and Doug Crane, and that's how Leon and I got involved in this program by default. That's the bad news. The good news is that Herman, Turkstra, and Laurel, Paul lined up some tremendous panelists, so I knew that my job would be very easy, and I'm honored to be in the same room with John Laskin, Ron Slaght, and John Murray. I should tell you briefly, as an old railroader, I thought that seniority counted. However, we had a discussion yesterday by telephone when Laurel lined it all up, and I soon learned that when my panelists told me that I had to do certain things, and I thought mainly all I had to do was introduce them. Ron Slaght said that I shouldn't introduce them, and I suspect the reason he didn't want that done, he wasn't afraid of me mentioning his CV, but he thought that maybe I would tell a little bit of the background that you don't know, because we are always told you should know your tribunal, and I think that should apply to this panel. Starting with John Laskin on my immediate left, everyone knows he's an outstanding counsel, but what they don't know are his shortcomings. For example, unlike his father, he did not have the benefit of being born and raised in Fort William, and therefore suffered from a Toronto upbringing. However, John was resuscitated when he was appointed one of the counsel to the Northern Environment Commission, chaired by Patrick Hart. I had the privilege of working with John on that commission, and therefore I can now vouch for John that he no longer thinks that Northern Ontario starts at Finch Avenue. Indeed, I can give evidence that under oath that John's been to Sioux Lookout, Pickle Lake, Red Lake, and Dryden, and so he's overcome that handicap of not being born in Fort William. Turning to Ron Slaght, many of you think that his chief claim to fame is that big win with Alan Lenzner when they won that gold mine in Northern Ontario for one of their clients. For those of you who don't practice mining law or haven't even had any contact with Northern Ontario, probably don't know that Ron's grandfather, the late Arthur Slaght, practiced first in Haileybury and then came to Toronto. When I was a student with the late Arthur Maloney, we shared space with a firm called Carrick O'Connor Coots, later became Carrick O'Connor Coots and Crane. When I joined that firm, Mr. Carrick told me he was a student with Arthur Slaght and later a junior, and I was told about Arthur Slat's ability as a counsel. And it's obvious that Ron has gained some of that background from his grandfather. By coincidence at that time, Mr. Carrick's secretary and my secretary for a short period of time was Ron's mother, Anne. Therefore, I knew at a very early age that Ron would turn out to be a very successful lawyer. However, I suspect...
I knew a lot about Doug as a result, too.
However, I suspect that part of his training is due to what the law his mother taught him, passed on from what she learned at Carrick O'Connor Coots and Crane. Now, John Murray on my far left is fortunate that I didn't know him as well or for as long a period of time. However, I think John is unique and probably better qualified than anyone else on this panel to deal with the subject of the professional under attack. I say that because John's partner is Eric Murray, and anyone who knows Eric can appreciate that John must have learned a great deal about professionals under attack. On one occasion, I was in the Court of Appeal, and Mr. Murray was arguing for a client who'd been convicted of charge of bookmaking or gambling.
If you're going to talk about the other Mr. Murray, then I'm going to interrupt you.
The client-operated premises where famous bridge players played bridge. The lower courts convicted the client because a charge was made for each game, and the lower court thought it was a game of chance. During a particularly heated exchange between Mr. Murray and the late John Aylesworth, At one point, Justice Teitelbaum indicated he'd heard enough from Mr. Murray because as far as he was concerned, it was a game of chance. Quick as a flash, Eric said, "Perhaps the way you play it, my lord." According to my instructions, I was told by my panelists that I would deal briefly with my paper, and I'm only going to deal with it in very, very brief form and then call on the panelists to deal with their subjects. It's in the material, and I thought I would just highlight perhaps 4 or 5 of the topics and then move on so you can hear from the real experts. The first matter I want to deal with is how to obtain a fair hearing, and I think that should be fairly obvious to most of you who've done any litigation at all, but obtain all of the facts you can, all of the particulars, obtain copies of checks, where you're involved with books and records, get all of the ledger sheets. You should do that because it's possible that you may judge it with 20/20 hindsight, and rather if you got all of the details and you turn it over to an accountant, you may turn up a defense. I can give you one example of where I was acting for a lawyer who was charged with misappropriating $100,000, a very serious charge. He had a serious illness, and I got his books and records and had an accountant look at them. It became obvious that there was about $200,000 worth of work completed, but not billed. I was able to develop a defense that he just didn't get around to doing the billing because he was seriously ill. He was waiting for a kidney transplant, and his books and records, he just didn't get around to doing it. The committee bought that. They reprimanded him in committee. If you want to talk to me after, I'll tell you who the panel members were in case you want to get an adjournment if you don't like the particular benchers on the panel that you're appearing in front of. The sad part of the story is about a year later he misappropriated $600,000. Unfortunately, he didn't come back to me, and eventually he was disbarred. But that's an example of what you should do to get prepared, because the books and records may not necessarily accurately depict what has happened. Another suggestion I have is the cross-examination of the professional investigator. And after getting all of the facts, and if you think it's relevant, retain a forensic accountant. And I can give you an example of one case where I was defending a solicitor who was allegedly cheating legal aid. The OPP were involved. They'd spent perhaps $50,000 to $100,000 in investigation. They'd done computer analysis. I retained a forensic accountant, and we were able to explain that what looked like fraud was not fraud. For example, in the tariff, the legal aid tariff, and I may have the numbers wrong, on a certain type of case, an adjournment is worth $57 or $47, and this lawyer charged $67. So the young accountant doing the work for the OPP thought $20 was fraud, and eventually they built it up to a few $100,000. And they also, in a computer analysis, found out that the person was charging for an appearance in a court out of town on a certain day, and the lawyer was billing about 6 months behind time and looking at a diary and didn't realize the case had been adjourned, and the computer analysis looked like she or he was charging for appearances that didn't take place. We were able to get the court records and explain that in fact there was a case, but it was on a different date. So sometimes the records don't accurately reflect what has happened. So if you get into that, and I must tell you that the sequel of the story is Mr. Sheriff, who was then the Senior Counsel of Discipline, withdrew the charges after he saw our professional accountant's report. Unfortunately for me and my client, the OPP were fairly stubborn. After getting our report, they bootstrapped their report, and eventually the solicitor pleaded guilty to fraud involving, I think, some $12,000, although even that sum of money was questionable because legal aid owed that lawyer about $28,000. I always thought it was an accounting exercise, so that particular story had an unhappy ending because that lawyer was disbarred. But it might be a good case for you to make an application to have that lawyer reinstated. The use of peer witnesses is obviously very important, because if you come to the discipline committee, I think it's a good idea to obtain good character evidence from respected members of the profession, and you shouldn't necessarily obtain a letter from some leading light in the community who is maybe an MP or a cabinet minister because in cross-examination, Gavin, MacKenzie, or someone else may bring out they haven't seen that person since they left law school. So you should tell your potential character witnesses, or at least I do, I send them a copy of the complaint. If the complaint is too long, I summarize it, and I ask them to put that in their letter that they're aware of the complaint. They obviously can't give evidence that the person is or is not guilty, but they can give evidence that this type of an offense is out of character for this in particular individual. And I think character evidence, in my respectful opinion, is very, very important if it's properly handled. A little tip I would give you is that if you're calling or you're going to submit a number of letters, I suggest you bind them to make the job easier for the benchers. Anything you can do to make your presentation attractive. The benchers are busy. They are appearing there free. You're appearing there being paid, or at least in theory, if not in practice. So if you can make their job easier, do so. I would suggest you not overwhelm them with too many oral witnesses. Although sometimes, if you have a key witness or two, that may be a very good idea. Use of psychiatric evidence. It's possible that in certain situations you can use a psychiatrist who's experienced before tribunals to develop a defense. For example, if you have a lawyer who has an alcohol problem, as I did once, and this particular lawyer was practicing in an alcoholic stupor from time to time, and he delegated the writing of trust checks to a clerk, and the clerk wrote trust checks and stole some money. You would think the lawyer would be automatically disbarred. However, with the medical evidence and the character evidence, and he was a gold medalist at U of T, he was suspended for a period of time, and the condition of his readmittance was that he had to file psychiatric and letters from doctors that he's recovered, and that in fact did happen. When I was retained by the Law Society in the distant past, I prosecuted a lawyer who was involved with issuing 5 writs in one file. Those of you who are old enough to know what writs are. And he was also allegedly taking money from clients. Claude Thompson, who was Gavin's mentor, appeared for the lawyer and called very persuasive psychiatric evidence about marital breakdown and a certain type of psychiatric problem, a destructive type of personality. That lawyer was reprimanded, or he was suspended for 2 or 3 years, and eventually he's now back in practice and living a useful life as a lawyer. The final matter, second final matter I'd like to deal with is the onus of proof. I think generally speaking it's on the balance of probabilities. However, you may have a case where a lawyer is charged with a type of a complaint that speaks in a criminal context. And I've had them where they allege he lawfully did participate in essence of a fraudulent bankruptcy. For example, at page C9 of the paper, I believe the complaint was something, and thereby did commit fraud on his creditors. I won't go into too much detail because the case is still under reserve and Mr. MacKenzie prosecuted, but I think that I've got the complaint reasonably. This was only one of many complaints, and one of the issues, and we filed written argument, was the correct burden of proof. Very briefly, I wanted to deal with the charter, but I'm going to leave that to John and perhaps Ron. But I deal with it in page C10 of the material. And I think in capsule form, the question may still be open, but it looks and appears to me at this stage that at least in Ontario, you won't succeed in a Section 7 charter argument. I can tell you a little bit about a case that I was involved in, and if you want to turn to page C22, Biscotti and the Ontario Securities Commission, there were 3 brokers involved in I guess what was Canada's alleged scandal, the stock exchange following the Boski matter in New York. There was Cosentini, Biscotti, and Orton, and I acted for Orton. The allegations were there was front-running and other breaches of the Securities Act. We attempted to get the sort of star chamber interviews that the OSC has with these people. Before my client came to retain me, months or before, he had been interviewed under oath, not by one, by about 3 members of the Ontario Securities Commission, including 1 or more lawyers, and cross-examined and no protection and leading questions. And we wanted all of that material to assist us in the defense. And I deal with that case at C-22, and it came before Justice Moldaver, and he rejected the argument that the Charter created a constitutionally protected right to earn a livelihood. By logical inference, he inferred that Section 7 rights are limited to freedom from bodily restraint. And then, if you would like to turn to the very back of the paper, I conclude that, as can be seen, whether the rights protected by Section 7 of the Charter apply to disciplinary hearings is still a matter of debate in Canadian constitutional law. On the one hand, the courts in British Columbia and Nova Scotia have held that the Charter affords protection to the right to earn a livelihood, and therefore confers this constitutional right to disciplinary hearings. On the other hand, in Ontario, Section 7 has been interpreted narrowly to include only freedom from bodily restraint, and perhaps a narrow class of other issues. In my opinion, the Supreme Court of Canada will eventually have to decide the issue, and I'm going to turn now to Ron Slaght, who I'm going to ask to, I believe he wants to deal with curial deference, and he can deal with any other matters that he wants to deal with. I thought Ron wouldn't mind if I told a brief story about my late principal, the late Arthur Maloney. I don't know if it relates to curial deference or not. He was being admonished by a trial judge who had a rather severe personality, and I guess at one point Mr. Maloney thought the judge had finished, so he sat down. In a rather crusty voice, the judge said, "Mr. Maloney, it's customary when trial judge speaks for trial counsel to stand." And quick as a flash, Arthur said, "Sorry, my lord, I thought you had finally finished." Ron Slatt.
I just will say a couple of words about curial deference, and I think it's a very important feature of this kind of work because having acted on both sides of these cases in a number of different settings, to me, curial deference is not too well understood, and the best thing about it from counsel's point of view is that it provides a weigh-in on an appeal from a discipline tribunal. Just 20 words about the current state of the law. There are two recent Supreme Court of Canada cases. AG and Mossop is one of them, and the other one, I forget the name of, I think it's AG and PSAC, in which the Supreme Court of Canada has now, it seems, made a distinction between specialized tribunals to which curial deference will be recognized and others. So what's a specialized tribunal? Well, I guess the Law Society and the colleges would be so. In the particular case, I think Mossop was the one they decided a human rights tribunal is not a specialized tribunal. So that's, I think, a new opportunity for counsel to go over the old curial deference ground. And what the Supreme Court of Canada also said was that as to matters of law, they do not, most of them say, they're not going to pay too much attention to what a tribunal says on a question of law, which is quite, extraordinary, I think, and new. And you should read those cases because, as we all know who do this work, there are, in the course of these hearings, many, many questions of law. And what's a question of law anyway? So it was quite surprising, and you should be aware that there is a sort of opportunity there to turn something into a question of law, trot out those cases, and of course they've done the same thing that they're doing all the time now. They write 14 judgments in the two cases, and you never know who's to be believed. But I think if you can take a principle from it, it's that if you've got a question of law, you've got to weigh in. The other point that I don't know if anybody wants to comment on is the increasing use of similar fact evidence in discipline hearings generally. There's a case in the Supreme Court of Canada 1990 case, R versus CRB in the 1990 Supreme Court reports that waters down, I think, the test for similar fact evidence sufficiently so that it makes it much more accessible to prosecutors in discipline cases. And so you're seeing a lot of it now. And that, again, is, to me, a question of law, the use of similar fact evidence, and is a useful ground of appeal if it's let in and used against someone in a discipline hearing particularly. So those are, I think, two changes or current things in discipline proceedings anyway that you should be aware of. The other observation I would make on the onus of proof, and to me, certainly in the committee that I advise, in any serious case, notwithstanding the Statutory Powers Procedure Act, which in non-Health Discipline Act cases applies, we adopt the criminal burden as the burden of the prosecution. You know, balance of probabilities, clear, convincing evidence, you can say it any number of ways, but the instructions that a lot of these boards have from people who advise them is, in a serious case, a sexual case, or a case of fraud, the burden of proof that the prosecution assumes is, whatever else you call it, the criminal burden of proof. And I have a divisional court experience where the divisional court gave lip service to even the admissibility of hearsay evidence, which is admissible under the Statutory Powers Procedure Act, but said that in these kinds of cases, they didn't call it the criminal burden of proof. They said, we're not going to be concerned about it because the criminal burden of proof was met, and words to the effect, that was a very good thing that was done, because I think that's what's going to eventually happen in these sex cases anyway. So I don't think you'll get admissions from prosecutors that that's what they are doing, but in fact, in my experience, that is what they are doing.
Do you hear that, Gavin? Okay.
Could I comment on the burden of proof issue, Doug? Doug doesn't know who I am or what my expertise is, so he knows my partner. That's actually quite reasonable, because when I was asked to speak here tonight, I said that my expertise didn't lie in disciplining professionals in the traditional sense. I act for a lot of universities, and I do a lot of labor law, so that in an employment context, I deal with professionals, and particularly in universities and healthcare. So really, I'm here in case anyone has a question on the social contract. But let me talk to you about the burden of proof for a moment. It's been, I think, traditional outside the formal discipline processes set up by professions to regulate themselves to deal with this burden of proof question in exactly the same way as was just discussed, and it is not news. There is substantial authority for the proposition in this jurisdiction, in any event, that the more serious the allegation, then the higher the burden. And it's not news. It's been around for years. Effectively, if you're alleging criminal conduct, the civil burden of probabilities will establish, will be only established on clear and convincing evidence, effectively a criminal burden. But that still is the civil burden, merely taking into account the seriousness of the allegation. So if one has a case of sexual impropriety, we know that there is a spectrum of misconduct which now can be viewed as being inappropriate, from poisoning the environment, somebody making gender-specific jokes every day, all day, is tiresome and ultimately probably is something that could be disciplined for. That burden is not going to be so significant, one would hope, as a sexual assault. So I think that that's exactly correct, and if the Law Society and other professional bodies have been slow to adopt that, I can't imagine a court would have difficulty in that particular matter. John's going to talk for a minute on curial deference.
Okay, you finished, Mr. Murray, you're not finished yet. You've got to explain what's the burden of proof when someone is charged with plagiarism, or they're caught in that swimming pool with their goggles on up at the U of T.
Those are straight balance of probability cases.
It's a very confusing area because everybody talks about it, and there's so much so many descriptions around of what it actually, what the burden is, that, you know, if you're not particularly experienced at it, you can get very confused.
If there is a criminal charge, though, for essentially the same misconduct, theft, for example, is something that's obvious, or sexual assault, isn't it clear if one is alleging something which could be a criminal offense that the burden of proof is effectively a criminal burden?
Well, I don't think it is.
Civil, so the more serious, that's just the more serious the allegation. I'm talking in practical terms.
Yeah, practically.
In practical terms, what the tribunal should do. What can it mean if Haynes and Wawanesa, I think is the case many years ago, which said that the more serious the allegations, the higher the burden. What can that possibly mean except that you effectively are meeting a criminal burden of proof in a civil case when the allegation is of criminal misconduct?
I'd like to agree with John. I don't know whether the tribunals, the Law Society, necessarily agree with it. I think they go as far as saying that it's closer to the criminal. I'd like to advocate, if there's any bencher in the audience, that they adopt John Murray's approach, but I don't think they necessarily do, because it's pretty serious when you take away someone's livelihood. That's just as serious as convicting them of some kind of a criminal activity.
Well, the reason you'll never get the tribunals to want to do it is because as soon as they recognize they've got a criminal burden of proof, then the charter is going to find its way into discipline hearings, and that's the worst sin that will ever happen as far as the college, any of the colleges are concerned. If the charter gets in, you know, then it's a whole new ballgame. So they can't and won't back away from lip service being paid to these balance of probability, clear, even if it's clear, convincing language, but because they can't afford to. But as a matter of practicality, I agree with John that they set out to prove the allegations on a criminal burden. So if you're defending and you approach it with that in mind, and then some similar fact evidence comes along, you know, it's really very helpful if you can put your arguments during the course of the hearing as if you're dealing with the criminal law in those questions, because I think you'll get a very good reception if you have to go to appeal. If you get the other side arguing that it's just a balance of probabilities, or that because the Statutory Power Procedures Act permits hearsay evidence, that's all they have to do.
I'd like to call on John Laskin. He proves his cases so well that he doesn't worry about the onus of proof.
I'm
It's
on
so
the other
overwhelming.
side. Well, I don't know, I mean, my answer, I think, to the last discussion about the burden of proof is, I guess the legal answer is, technically, I guess we have the Bernstein standard, which is supposed to be at the high end of the civil standard. I think my practical answer to the problem is that you can't win a professional discipline case unless you put your client in the witness box. And when you put your client in the witness box, his peers, or his or her peers, are going to be making some judgment as to how reliable his or her evidence is. And to me, I don't care what ritualistic formulas you put down as to what standard of proof is applying. That discipline committee is going to go back in the back room and make some judgment as to whether they think your client is telling the truth or not, and is to be believed. And to me, that's the long-run practical answer to the problem. I just wanted to just spend a couple of minutes, I guess, discussing what I think are probably the two most important practical admonitions that I could suggest this morning when you're defending a discipline case. And then I just wanted to say a word about deference and a word about the charter. For me, the two most important admonitions are, number one, to remember that a discipline proceeding is not a two-sided proceeding, that it's not just a contest between the professional and the prosecutor, that in fact there is a third interest out there, and that third interest is by far and away the most important interest, and that's the public interest. And I think a lot of us sometimes forget that the public interest surrounds all discipline proceedings. And I don't think you can do very well as a defense counsel in a discipline proceeding unless you are prepared to address the public interest and to persuade the committee why it is that your client does not need, or why it is that the public does not need to be protected from your client. It's in part for that reason that if you're doing law society work, I don't think it's terribly helpful to go back in time to about 1980 or 1981 or 1982 and see what law society discipline committees were doing with professionals. Because what's happened is that way back then, as most of, or if not all of you in the room may remember, rightly or wrongly, and I think wrongly, the Law Society was holding its discipline hearings in camera. There was no publicity, there was no public scrutiny of discipline proceedings. Of course, all of that has changed in the last 4 or 5 years. There's now intense public scrutiny of discipline proceedings, and be it the legal press or the medical press or the general press. And I think that has simply heightened the awareness of self-governing bodies and those who run them of their need to fulfill their mandate to protect the public interest. So I'm not at all confident that the way in which a committee decided a case, say 10 years ago, would be the same result today. And I'm not at all certain that precedents that you can find, if you can ever find them, which is another problem, from 8 and 10 years ago are very helpful. So one admonition I suggest to all of you is that you've got to be very conscious of self-governing bodies' mandates to protect the public interest. And if you have a proceeding, as almost all of them have now, where at least one member of the committee is a lay member, that lay member particularly is going to have an overriding concern to protect the public. I guess the second admonition I would suggest is that never forget that these people who are deciding these cases are invariably part-time, unpaid adjudicators. And we, as defense counsel, have to do everything we can to make their lives easier. They will like you a lot more and like your client a lot more if you can minimize hearing time for them. So don't get in the business of fighting about things that aren't worth fighting about. And try as best you can to reach an agreed statement of facts on everything that you can agree on with the prosecutor. That always has a number of collateral advantages, not least of which is that you manage to dehumanize the prosecution's case in doing that. And secondly, believe me, there is nothing worse than having a tearful complainant coming forward telling the discipline committee in graphic terms just what your client has done to him or her over the past 2 or 3 years. Performances like that are to be avoided by the defense at all costs. So try to get an agreed statement of facts. I always try to get an agreement whereby I pin the prosecution down to agreeing not to call further evidence on the points that are set out in the agreed statement, but still leaving the defense the right to call further evidence on those points if the defense sees fit. 2 problems with agreed statements. Problem number 1 is what you do with your agreed statement and your admissions if your client is also facing companion proceedings elsewhere, as is often the case, for example, criminal proceedings or other civil proceedings. The last thing you want is an admission in the discipline proceeding to be used against your client in another proceeding. And that's problematic. And I don't know whether you can do much more than expressly state that your agreed statement and your admissions are qualified for the purpose of the discipline proceedings and for use only in that proceeding and no other proceedings. The second problem that sometimes arises is you work out a deal with the prosecutor and you've got an agreed statement and a joint submission on penalty, and for some reason unknown to you and unknown to the prosecutor, the committee rejects the agreed statement or rejects the joint submission on penalty. Now your whole joint submission is founded on your agreed statement. So then you're in this horribly unenviable position as a practical matter, which I've been faced with once before, where your clients agreed to facts you might not otherwise agree to in order to get a deal, and the committee's told you they're not going to accept the deal. So you're then stuck with the agreed statement. I think all you can do, and I wasn't smart enough to do it at the time when it confronted me, is to make the point that the joint submission was founded on the agreed statement, and if the joint submission is not acceptable to the panel, then you're withdrawing the agreed statement and you're asking for a hearing on the merits before another panel. I think that is about all you can do. I've got 2 quick points on deference in the Charter. Much to my chagrin, and notwithstanding whatever the Supreme Court of Canada may have said recently on judicial deference, I still believe that insofar as the Law Society is concerned, judicial deference of the broadest kind will continue to prevail in connection with Law Society discipline proceedings. And the passage that I referred to in my paper at the top of page 6, Justice Corey's passage in Stevens many years ago, I expect will still be the law. For the life of me, I do not understand that principle, I say with respect to anybody who may be around here, but I profoundly disagree with that proposition in respect of Law Society proceedings. We do not have a definition of professional misconduct or conduct unbecoming in our statute. We're unlike the health disciplines. There's no guidance from the statute or the regulation as to what constitutes professional misconduct. We don't have a proper reporting service, so we don't have a precedent system for discipline cases. Can't go back in the reports and find out what has happened. And thirdly, I mean, when all is said and done, these discipline cases are being decided by benchers who are elected for 2 or 3 year terms and who may hear 4 or 5 discipline cases over the space of, say, 3 years. So I don't know. If we're up to me, I think there is not a bad argument that could be made that all of the policy reasons that underlie judicial deference to decisions of administrative tribunals may be questioned in connection with discipline proceedings. This isn't a specialized tribunal like the Labor Board, which is an ongoing tribunal which sits day after day and hears cases day after day and has a specialized jurisprudence and a developed jurisprudence, and you can go to the Ontario Labor Relations Board reports and so on and see them all. I mean, that isn't this tribunal. And why, for the life of me, appellate judges insist on giving the kind of deference they do to decisions of discipline committees, I find hard to understand, but enough said. One word on the charter. Lawyers got into the business of seeing whether the charter would apply in discipline proceedings because what we have tried to do is bring in through the back door, if you will, of Section 7 of the charter, all of the protections that accused in criminal proceedings have under Section 11. And the so-called interesting new issue in charter law before discipline proceedings is whether there is a so-called ask-off defense in discipline proceedings. And there was a judgment of Madam Justice Wilson's in a case called Wigglesworth, which I'm sure a lot of you know, in which she suggested that Section 11 protections don't apply to discipline proceedings, but you might be able to get the same result through Section 7. So with that standard, along came a lot of lawyers, and they started pushing a sort of ask-off defense under Section 7. And it has been given effect to in a number of provinces other than Ontario. It has been given effect to in Newfoundland, and it's been given effect to in a couple of western provinces where inordinate delay has been a defense. Inordinate delay on the part of the prosecution has been a defense to a discipline charge. Now, inordinate delay in and of itself isn't enough. You've got to show some actual prejudice. But if you can put delay together with actual prejudice, so the cases out west and the cases in Ontario and Newfoundland say maybe you've got an ask-off defense. The problem with it in Ontario is precisely what Doug Crane said. Ontario has taken a very different, in my view of Section 7 of the Charter, and a much more limited view than a lot of other provincial appellate courts. So I'm not sure yet whether our Ontario courts are about to receive that defense. The Supreme Court of Canada ducked the issue in a case called Herman in the Manitoba Law Society. It was raised before them. Justice Iacobucci wrote for the court, said he didn't have to decide the issue in that case, and didn't. I guess that issue will percolate around the provincial courts for a while until the Supreme Court decides it.
Thank you, John. John Murray, did you want to comment on the...
Well, I really had a comment and maybe 2 questions for John Laskin. On the point of curial deference, I think those of us who've been, and I'm sure a lot of you have been before the divisional court, will understand that the court does have, I think, a couple of problems. Number one, it wasn't what McClure thought it might be, and that is a repository of its own wisdom on administrative law with justices sitting regularly. There are a lot of judges who don't have tremendous experience with administrative law and are not inclined to listen to technical cases from lawyers. And the reality is that one cannot expect to have any kind of appeal. I know judicial review isn't supposed to be an appeal, but it is not something to count on in the absence of some blatant disregard for natural justice. The theory of curial deference is run amok. I agree with what John Laskin has said. Now on to the two questions. First, on the agreed statement of facts point and the risk of prejudicing one's client in another proceeding, just like to ask whether in discipline matters, particularly in the Law Society or I suppose in colleges, physicians or whatever, it would be possible in order to avoid that risk to have essentially have it conceded that if the following evidence was called, it wouldn't be contested, and then avoid the necessity of putting a witness in the box, or in fact have a witness go in the box, even if one prosecution witness, even if the evidence is hearsay, on the stipulation that it isn't going to be challenged as to its veracity, and avoid the admission that way, which is what I've done in some environmental cases with potential criminal sanctions, and has been accepted, so that the admission is never made, but there's no contest on the facts, and it's clear to everybody what's going on. And the second question, which do you want me to wait for that, or do you want to?
So I'm just going to make a brief comment on the agreed statement of facts. Gavin, MacKenzie, and I had a case recently where we exchanged agreed statements of facts, and we used scissors and paste. And in that morning of the hearing, we used part of Gavin's and part of mine, and one of the benchers, I won't mention his name, seized on something and said, well, Mr. Crane, you're backing away from the agreed statement of facts. And there was a little bit of inconsistency in one of the paragraphs. So I urge you, if you're using agreed statement of facts, to do two things. Make sure that it is accurate. I got out of that problem by explaining to the bencher that the agreed statement of facts was only part of it. We also filed 7 exhibits that morning and some character letters. With respect to the fear of those agreed statement of facts being used in subsequent proceedings, I'd like to draw an analogy to the criminal practice where if you're entering a plea, you can speak to the Crown, and hopefully if he or she has some experience, you can persuade them to water down everything that's there and just get an admission of bare bones, not all the blood and gore that goes into the Crown brief. And you might try that tactic in a Law Society hearing so that hopefully there's just enough to warrant a, quote, a conviction, but not enough to support any kind of a subsequent hearing. Anyway, what do you say, Ron? Are we all wrong?
No, I just wonder about the practicality of John's suggestion. My attitude to agreed statement of facts with non-Law Society matters, but dealing with people who are not lawyers, is that they're very receptive to them, and they tend not to nitpick or worry very much about things that that lawyers would worry about, this kind of problem that Doug suggested. On the other hand, they don't seem to get used very much in my practice or experience, because people don't seem to be able to agree on anything.
Contentious as ever.
Well, I guess I don't know whether my question's been. Let me give you a specific example in another context, and surely that must be analogous in discipline proceedings. I had a client charged with an environmental offense, which could have meant very substantial civil liability for polluting downstream waters of some local Toronto gentry who had farms in the North Country. And that was their experience in the North, Doug.
With overalls on.
Yeah.
They have overalls.
So to agree to any facts at all, which was problematic because of the civil liability, and I think that was the question that John put to us. So I'm not talking about the difficulty or ease with which one can agree. I'm assuming there is an agreement, essentially, on the facts. And my question then is, how do you avoid making the agreement, but also taking the benefit of it? And my narrow question is, would it not be sensible to have a sort of a nolo contendery on the facts, but not admit them? And that way avoid the potential implication. And whether that's maybe not a smart question, I don't know.
No, it's a very good question, and I think it's a sensible approach if you can get the prosecutor to agree to it. The Ontario Securities Commission is a good example of a body that will accept an agreement on the basis that John Murray has just set out. And there are many OSC agreements that set out this will be the prosecution's case, and the respondent registrant offers no evidence in response to those allegations. And the Commission routinely makes orders on the basis of what amount to agreed statements on the very basis that John Murray set out.
You used to be able to do that in North York Criminal Court. We used to call that the Willowdale trial. and it was precisely that.
The second point I had is the question of ask-off and delay. There also is some evidence in human rights cases, particularly outside the province, that delay in bringing complaints to tribunals can be so prejudicial as to, in fact, make the process itself come into question on the basis of delay. And the question I had, if you had an ask-off type argument, John, would you make it to the tribunal or to the court first?
I think you should make it to the tribunal first. Myself, I think you should give the tribunal the opportunity to deal with a case like that, and I think there's no doubt that obviously tribunals can apply the charter. That's without question. They can apply Section 52 of the charter. There may be a little bit of debate going on right now between some of the judges in the Supreme Court of Canada as to whether they can affect a Section 24(1) remedy under the charter, which is really what you're asking for in connection with ask-off. But I think there's enough jurisprudence up there to suggest that you can give a Section 24(1) defense, and I think it's better to give the tribunal an opportunity to deal with the matter before you rush off to court.
I agree with that.
I agree too, and I'm from the old school and brought up by Walter Schrader and John Aylesworth, and the first question they'd ask you when you were arguing appeals is whether the lawyer in the lower tribunal or in the criminal court or the civil court had objected to what went on in the courtroom or to the jury charge, and usually if you said no, you were in real trouble. So I agree that you should raise your objection before the tribunal.
You got to make this Section 7 argument, it seems to me, though, you got to get it out of the economic realm. I mean, you have to ask yourself, what are the Section 7 interests that are being protected here? If you've got a liberty or security of a person interest, I mean, what is it? If it's just economic, we all know the Charter's not there to protect economic rights. It's not going to get you anywhere. So you've got to turn the economics into an interest that is recognized under Section 7, something akin to dignity or self-worth or something. You know, pick up on Madam Justice Wilson's judgment in Morgentaler, where she talks about the range of interests that are protected under Section 7. And employment is an interest, not in an economic sense, but more in a sense of employment or working being essential to an individual's dignity, his self-worth, and so on and so forth. I mean, that's where you've got to make the argument.
I agree with that completely. And just on that point, you might find that the comments of the Supreme Court of Canada in the mandatory retirement case are helpful on that point in terms of dignity and self-worth. The other thing is that in the strict ask-off sense, the human rights cases decided by courts, particularly ones outside this jurisdiction, also focus in exactly on what John Laskin has said, particularly in cases where there's an allegation of sexual impropriety, which may have been hanging over an individual for some years, and there are quite well articulated criteria for the application of ask-off in exactly the way John suggested, so there's some help out there.
Ron Slaght, would you like to make a comment?
I'd just like to follow up on something that John Laskin said about this third-party public interest in the face of all these tribunals. And of course it's right, and you do have to have that distinction in your mind between that setting and any other setting when you're preparing. And these days, it's very much on the minds of all the discipline bodies, I don't think so much the lawyers, but maybe the lawyers too, about this great public interest, need to protect the public interest. I say, though, that when you actually get to the hearing, it almost works to your advantage in the individual case, in that I find that the actual triers of fact, notwithstanding the great need to protect the public interest, and all the statutes are designed to do that, seem a little more willing now to give the benefit of the doubt in the actual hearing to the accused, if I can use that word, so that while you go in with the idea, gee, you know, they're going to do something because they have to be seen to be doing something about this problem of sexual assault of patients or fraud on the public. When you actually get in there, there is a real natural human inclination, I think, in the triers of fact, to bend over backwards now to give a fair hearing. And the problem is, the lawyers often get in the way. I think when you're a lawyer acting in front of one of the colleges, or the accountants, I guess would be so, you can't do it like you do it in a court. I don't think you can anymore. These people are sophisticated people, and they do not like lawyers doing lawyer-like things. They really don't, and they will hold it against your client. So I think practical lesson, tone it down. As John says, you got to put your client before the tribunal, and you should be doing that with the least amount of obstreperousness and technical objections, because they just don't like it, and it takes away from their inclination to help, to really want to help when the lawyer becomes the center of attention. So I think you can't act like you act in court. You've got to be quite different in front of a discipline panel of these now sophisticated colleges and other tribunals.
Thank you, Ron. I think I'd like to turn it over to the audience, and I see that Gavin MacKenzie is championing at the bit. I think he wants to announce the criminal burden will now apply in discipline hearings. Do you want to come up and announce it here, Gavin?
What I really wanted to do was just make an observation about the point that John Murray made about what you can do with agreed statements of fact to prevent them from being used against your client in parallel civil or criminal proceedings. I've been involved in cases in which both of John's ideas have been effected. I've led hearsay evidence with the consent of the defense counsel, so that there's no admission that's made that can be used against a lawyer in parallel criminal proceedings. And I've also been involved in cases where, in effect, there's a nolo contendere plea, where the lawyer, in effect, says, for the purpose of this proceeding only, I don't contest these statements without admitting them. One further idea that I might throw on the table, which I've seen used effectively in a case as well, is you might have the agreed statement of facts covered by an affidavit from the lawyer, in effect saying that for the purpose of this proceeding, I acknowledge these facts. The reason for doing that is that if anybody tried to use that in a criminal proceeding and introduce it into evidence, it would be protected under Section 13 of the Charter, whereas an agreed statement of facts, which wouldn't make the lawyer a witness, might be admissible as a statement. The affidavit from a lawyer who is then a witness in the proceedings might be protected under Section 13. So that's just another idea.
Okay. Thank you.
It's a good idea.
Any other questions out there, the audience?
It's a great idea.
You must have one, Leon.
What about discovery? Finding out what the case is about before you get in front of the tribunal. I'm not necessarily so much concerned about the law society, but a number of the other tribunals seem to have no real mechanisms for discovery.
Well, Stinchcomb, I guess, is the new law, and in my experience, all boards are complying with Stinchcomb, and you should insist that you get a Stinchcomb-like disclosure from any tribunal.
Yeah, great.
So I think it's really a new game there.
Yeah, that's awesome.
And I read, I think maybe it was Julian's paper. I wouldn't be so quick to agree with them that they always did it. I don't think that was so. And so it is new, and many of the smaller tribunals who don't meet very often, they don't even know what the rules are. So often defense lawyers have to educate them as to their responsibilities and put these things in front of them. But nobody should accept anything less than Stinchcomb.
I agree with that, and I can comment from my own experience. Sometimes in universities, the prosecutions have fairly serious implications. Inappropriate conduct in research, for example, could involve the false recording of patient response in a medical or clinical setting, which would lead to false conclusions of medical research, and those can be extremely serious, not only for the career at the institution involved. And in cases with, I've been surprised at how often lawyers acting for sometimes clinical faculty, sometimes professors, don't ask for full disclosure. I normally insist on providing it in any event because we are talking about the careers of men and women who are professionals, but it's quite surprising to me how often those demands aren't made on some, I suppose, expectation that they're not entitled. So I certainly underscore what Ron said.
Doug talked about, I agree with that, Doug talked about character evidence just briefly, and I just add a word or two about character evidence. I must confess, having done this work for a lot of years, I still am not entirely confident in my own mind as to how much character evidence weighs on a particular member of a discipline committee, but I think on balance, in most cases, character evidence is important. And it's important not just on the question of penalty, where most people would think it is only important, but it is also important on the question of whether or not your client is guilty of professional misconduct, particularly where credibility is a question, because discipline committees now routinely accept character evidence on whether or not your client is or is not a truthful person or a person of integrity and so forth, as bearing on whether or not your client committed the conduct with which he or she is alleged. I also think it's important to go beyond your peers in getting character evidence. To me, it's very important to get character evidence from the public. Again, it goes back a bit to this public interest point. But I think committees, to the extent they're going to be interested in character evidence, are going to be interested in what members of the public who know your client think about your client. So I strongly advise, if you're putting in character evidence, to get evidence from those sources. And I agree entirely with Doug. It's no use getting some general letter from your local MP or MPP or from some renowned person in the profession who doesn't know your client. And if you're doing law society work, it's tough to get letters from judges because judges have essentially been discouraged from giving those sorts of letters by various chief justices and so on. You're much better off getting a letter from somebody who really knows your client and can speak about your client in very personal terms from long-standing knowledge.
I agree with John. When I meant peer witnesses, I maybe should have mentioned that, but it's in the paper. I also think it's a good idea if you can get a client to say that he or she is very confident dealing with the lawyer, and if the lawyer gets out of this particular problem, he or she continues or would continue to use the client. If you can get those type of character witnesses and clergymen and etc. Any more questions?
Just on that point, I've seen two cases, which is quite interesting, the use of character evidence to combat similar fact evidence being led by the prosecution. The idea being that the similar fact evidence is designed to be probative of a course of conduct inconsistent with the story being told by the accused, again I'll use that word, and character evidence being led, because it is a matter of credibility then, character evidence being led to suggest that the person would tell the truth. It's admitted.
Okay, I think it's almost time to conclude. I'm wondering if I can tell you one quick story. When we were at a dinner, at an Advocate Society dinner in London, I see Paul Jewell up there. One of the speakers went on and had a little bit too much to drink and was barely audible. And Lord Wilberforce got up to thank him and said it was a Rolls-Royce performance. Lord Salmon got up and was sitting beside him rather and said, "You're a hypocrite. How could you say that was a Rolls-Royce performance?" And he said, "Well, that's simple. It was well-oiled, it was barely audible, and it ran on forever." Now, hopefully you won't accuse our distinguished panel members, excluding me, of being guilty of that. Thank you very much. Thank you, John. Thank you, John.